Loyalty oaths have been a big controversy this election cycle, but the problem goes more toward the rules than it does the actual loyalty oath. Where the Republican Party is a private club, and we're allowed to set our own rules. However, there are some exceptions. We can't make up any rule that violates state law or attempts to change any state law. And that's precisely what's been happening. I believe the attorneys advising leadership has done the Republican Party an extreme disservice in their interpretation of some of the legal statutes. Number one, it states in the Florida statutes that our rules have to be posted at the Division of Elections. Whenever we change our rules, it's impossible. I mean, who expects us to send our rules to 4 million voters? You know, that's ludicrous. What we have to do is post those rules at the Division of Elections so they become public record. This came to my attention because we were trying to gauge the different candidates' election chances the way it was. It was by congressional district. And if you notice the elections, Mitt Romney actually took 5 or 6 of the congressional districts within Florida, and John McCain took the others. Now, if the rules would have been the old way, Mitt Romney would have got some of Florida delegates. But because of the rule changes, the party gave everything to John McCain. However, the rules were not filed with the Division of Elections, so this could have caused a court challenge if we would have had a brokered convention. So the rules were not followed according to the state law. Now, when we were all on conference calls in May and June talking about new rules and new loyalty oaths and what everybody needed to do to become members of the executive committee, they went back and forth, the attorneys and the advisors of leadership, with the Division of Elections. They wanted to do it one way. The Division of Elections says you can't do it. And finally, the leadership put together a rule saying that the party loyalty oath had to be filed by June 20th. And once again, the attorneys that advised leadership did the Republican Party a very big disservice. According to state statute, our rules have to be filed with the Division of Elections. And you know, that rule was never filed with the Division of Elections. And that makes everything invalid. There's a lawsuit going on in Miami-Dade where the judge actually seated, I believe, 19 people that didn't file the loyalty oath. In some counties, people that filed or did not file the loyalty oath are still getting seated, where other people are not. There's no rhyme or reason to the rules. If we're going to have rules, they should be applied uniformly. And this is my main problem with the loyalty oath. I don't have a problem with the loyalty oath as long as everybody is treated fairly and there's no selectivity in enforcement. But I know for a fact that there are several counties where executive committee members have donated to Democratic candidates. It's on their election report. They've donated, we have Republican executive committee members that donate to Democratic echoes. We also have Democratic or Republican candidates that openly support Democrats and independents. Some people, that's a violation of the loyalty oath. With some other people, they're not. And if we're going to have a loyalty oath, it has to apply to every single person, or it can't apply to anyone.